Okay, let's unpack this. Every time you pick up a bottle of wine, or maybe a six-pack of craft beer, even a traditional fermented drink, you're actually holding something that's been, well, meticulously mapped out by law.
Uh-huh. It's not just about making sure it's safe to drink, though that's obviously key. It's also about defining what these things are. What legally counts as wine or beer? The law draws that map.
And that map we're exploring today is the Liquor Products Act 60 of 1989. Now, you hear 1989 and think, that's pretty old, right?
Right, it is foundational. But the key thing is it's constantly updated. I mean, the version we're looking at incorporates changes right up to October 2024, so it's very much a living piece of legislation.
Yeah, and those updates tell a story. Like, there was a big one in August 2023 that cleaned up the language, got rid of terms like chairman, switched to chairperson.
Exactly. And it consolidated the main regulatory body, sometimes called the board, into just the authority. It shows the act adapting even while its core job stays the same.
So what is that core job? What's the big picture goal here?
Well, if you glance at the preamble, its mission is super clear and, honestly, quite broad. It's there to control the whole life cycle of liquor products.
The whole life cycle.
Yeah, specifically focusing on, four main things. How they're sold and produced, what they're actually made of, their composition and properties.
Okay.
Then, how labels and ads are used, the particulars, as the Act calls them, and finally, crucially, control over import and export. It covers a lot of ground.
Right, so if that's the what, then who enforces all this? Who's the referee making the calls?
That brings us to the regulatory architecture. And what's really interesting is how much power is centralized in the Wine Certification Authority, just the authority for short.
The authority, okay.
And it's set up as a juristic person. Now, for you listening, that just means it's a legal entity in its own right. It can sign contracts, own things, even be sued.
Yeah.
Gives it teeth, essentially.
And who sits on this authority? Is it just government folks?
Oh, no, that's the clever part. They've structured it to bring in real expertise. It's got members, I think 15 in total, with deep knowledge in things like viticulture, grape growing.
Right.
Enology, which is the science of winemaking, distilling, food safety, really specialized stuff. And importantly, these people often represent the participants in the schemes. So the industry itself has a voice.
Industry having a voice, that's interesting. What about other perspectives?
Well, significantly, the Act mandates that if the authority is dealing with schemes around ethical trading standards, it must include 2 representatives of workers.
Ah, okay. So trying to balance commercial interests with maybe social responsibility?
Seems like it. Plus, you also have officers from the relevant government department and someone nominated by the Agricultural Research Council. So it aims for a pretty broad base of knowledge and viewpoints.
And there's an administering officer, too. What's their role?
Right. That person is designated by the minister. They're the ones actually carrying out the day-to-day duties the Act imposes. They can also delegate powers, which makes sense given the scope. Okay, structure makes sense. Now let's get to the products themselves. You mentioned the Act defines them. How strict is that?
It's incredibly strict. Section 4 lays down a fundamental rule. You basically cannot sell or even produce for sale any product meant for drinking that has more than 0.5% alcohol by volume.
0.5%. That's the line.
That's the line. Unless that product fits into one of the specific categories of liquor product defined in the Act.
And are those definitions keeping up with the times? What about new kinds of products?
They seem to be trying. For instance, the definition explicitly includes products in powder form that you mix to make an alcoholic drink. That shows they're looking beyond just traditional liquids.
Interesting. So what are these defined categories?
Okay, the main ones listed are wine, alcoholic fruit beverage, beer, traditional African beer, other fermented beverage, spirit, grape-based liquor, and spirit-based liquor. Each has its own detailed definition.
It really sounds like a legal recipe book. Can you give us an example, maybe compare a couple? Sure, let's take beer and traditional African beer. They sound similar, but the legal definitions create a clear divide.
Okay.
For beer, Section 6A says it has to be made from wort. That's the sugary liquid brewers start with prepared from starch or sugar sources. And critically, it must be flavored with hops or hop products.
Hops are key for beer, right?
Absolutely. But there's another crucial bit. At least 35% of the fermentable stuff, the sugars that become alcohol, must come from malted barley or malted wheat.
35%. Why that specific number? What does that achieve?
Well, think about it commercially. Malted barley or wheat is often more expensive than, say, using mostly rice or corn syrup. That 35% minimum ensures that what's legally called beer retains a certain character, often linked to traditional brewing styles.
Ah, so if someone made a drink fermented entirely from, I don't know, rice and flavored it with hops, they couldn't legally call it beer.
Exactly right. They'd have to use a different classification like other fermented beverage, maybe. It protects the identity and perhaps the market value of traditional beer. Its definition as market protection.
Fascinating. Now, contrast that with traditional African beer, Section 6B. What's the definition there?
Okay, this one has to be produced from grain malted or unmalted, specifically sorghum, maize, or millet, those traditional African grains.
Right.
And here's a major difference. It must not contain or be flavored with hops. The absence of hops is actually part of its legal identity.
No hops allowed. What else?
And another really interesting point. Unlike most commercial beers that are filtered clear, traditional African beer must contain at least 4% solids derived from the grain or meal used to make it.
4% solids. Why mandate that? What's the effect?
It means the beer has to be, well, substantial, cloudy, perhaps a bit thick. It legally preserves that traditional, almost food-like character. It stops producers from filtering it heavily to make it look like a commercial lager, which would strip away part of its identity.
So the act is trying to walk this tightrope, isn't it? Preserving cultural heritage, but within a framework of industrial quality control.
That's a great way to put it. It's regulating tradition, in a sense.
Okay, so we have these incredibly precise definitions. How does the act then stop people from, bending the truth on a label or in advertising? How does it build consumer trust?
That's where Section 12 comes in the prohibition on misleading descriptions. It's quite broad. It basically says you can't use any name, word, picture, symbol, anything, really, that creates a false or misleading impression about the product.
An impression about what, specifically?
About its nature, its quality, where it came from, its origin, its age, or its composition. So if your label says wine, that product better meet the strict legal definition of wine we talked about, made from grapes of a prescribed type, potentially with prescribed grape spirit added, and nothing else unauthorized.
And does this extend to using famous regional names? Like, could someone in South Africa make a sparkling wine and hint that it's like champagne?
Ah, good question. Section 13A tackles geographical names directly. The minister can restrict using these names, even if you try to qualify it by saying kind, type, or style, or imitation.
And why would the minister do that?
Crucially, the Act says the minister must consider the Republic's international obligations. Think about big international agreements like TRIPS, trade-related aspects of intellectual property rights, or specific deals like the wine and spirit agreement with the EU.
So basically, South African law prevents local producers from using protected European names like champagne, port, or sherry because of these international treaties.
Precisely. You can't call your local fortified wine port style. The domestic law locks into these global IP protections. It's essential for maintaining good trade relationships.
And this control obviously extends to actual imports and exports, too.
Yes, Sections 16 and 17 handle that. Any liquor product over that 0.5% alcohol threshold needs an import certificate to come into the country or an export certificate to leave, issued by the administering officer.
What happens if something comes in that doesn't comply? Say it's mislabeled or doesn't meet the composition standards.
The authorities have the power to deal with it. Non-compliant imports can be ordered removed from the country, or they might require some kind of treatment to bring them into compliance. Failing that, the goods can be seized, destroyed, or forfeited to the state. It links domestic standards directly to border control.
That sounds like serious enforcement. Let's talk about the teeth of this act. What powers do the inspectors, the officers, or authority agents actually have?
They have quite significant powers of investigation under Section 18. They can enter any place, premises, or vehicle at any reasonable time if they suspect the act is being contravened.
Any premises, even someone's house.
Well, for a private dwelling, they need either the consent of the occupant or a warrant issued by a judge or magistrate. But for commercial premises, the power of entry is broader.
And once they're in,
They can examine anything relevant, the product itself, materials, equipment, books, documents. They can take samples for analysis by a designated analyst. They can demand information and assistance from the owner or person in charge.
But is there anything they can't demand? Any protection for trade secrets?
Yes, there is a really important limitation in Section 18, subsection 3. Officers cannot demand information that would reveal a secret formula or recipe used for producing or blending the liquor product.
Ah, so the secret recipe for your craft gin or your unique wine blend is protected.
That's the idea. It balances the need for regulatory oversight with protecting legitimate commercial confidentiality and innovation. It's a key point for businesses.
Okay, so what happens if they find a violation? What are the consequences, the penalties?
The penalties outlined in Section 23 are definitely not trivial. For a first conviction on major offenses like selling a product that doesn't meet the definition, or obstructing an investigation, you could face a hefty fine or imprisonment for up to 2 years.
2 years for a first offense. Wow.
And it gets steeper. For a subsequent conviction for the same kind of offense, the maximum imprisonment doubles to 4 years. The Act treats noncompliance very seriously.
Now, there's something called vicarious liability in Section 26. This sounds like a huge deal for business owners. What does that mean, practically?
It is a huge deal. Vicarious liability means the principal, think the company owner, the director, the main producer, can be held legally responsible for offenses committed by their managers, employees, or agents, even if the principal didn't directly commit the act or even know about it.
So, if my bar manager waters down the spirits or an employee sells something incorrectly after hours, I could be the one facing that 2-year sentence.
Potentially, yes. The act essentially presumes the principal committed the offense if their employee or agent did it while acting within their scope of work.
Is there any defense?
Yes, but the burden of proof shifts completely. The principal can escape liability only if they can prove that they did not permit or connive at the act, that they took all reasonable steps to prevent it, and that the act didn't fall within the employee's scope of authority anyway.
All reasonable steps. That sounds like it requires really robust internal controls, training, and monitoring systems.
Absolutely. You can't just say, oh, I told them not to do that. You need to demonstrate active, reasonable measures were in place to prevent the offense. It forces businesses to take compliance incredibly seriously throughout their operations. It's a massive legal hook.
Okay, one last legal point. Does the Act offer any protection for the regulators themselves, the officers doing the inspections?
Yes, Section 31 provides a limitation of liability. Essentially, officials or authority members acting in good faith while performing their duties under the Act are protected from lawsuits or damages arising from their actions.
That makes sense. You need regulators to be able to do their job without constant fear of being sued personally for enforcing the law.
Exactly. It's a standard feature in regulatory law. Helps ensure robust enforcement.
So, bringing it all together, the Liquor Products Act really is this comprehensive system, isn't it? It's setting standards, defining products, protecting consumers, controlling trade, and enforcing it all quite strictly.
That's right. It's trying to create a level playing field, guarantee a certain quality and identity for these products, and manage everything from the vineyard or the grain silo right through to the shop shelf and the export market. It connects agriculture, industry, consumer protection, and international trade law.
It's quite a feat of legal engineering.
It is. And if we loop back to that idea of tradition versus modernization, especially with something like traditional African beer, the Act uses these sort of industrial metrics, minimum solids content, no hops, to legally define and protect something that originates in cultural practice.
Which leads to a final thought for you, the listener, to mull over.
You can consider this. How well do you think this kind of detailed, legalistic regulation actually works when it comes to preserving the cultural identity of a traditional product? Does setting a minimum solids percentage truly capture the essence, or does it inevitably change it by forcing it into a standardized, commercially viable box? Where do you think that balance lies between respecting tradition and ensuring modern market standards? It's a constant tension.